Welcome to SpringLaw's 2019 Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit SpringLaw at www.springlaw.ca. And now to our presenters.
Welcome to Spring Forward Legal Updates, our monthly webinar series. Today is the 7th of our 2019 monthly webinars, and the topic, as you all know and can read, is employees with disabilities, attendance management, and termination. I am Marnie Baizley, and I'm joined by Hilary Page, and we're both lawyers at SpringLaw. If you're one of our clients, you already know that we're employment, labor, and contracts lawyers at our virtual firm, which is based in Ontario. And we specialize in all types of legal issues that arise in workplaces. So if you're new to our law firm community, welcome. During the webinar, feel free to ask questions through the chat function. If we can't get to your questions during this half hour, we'll be sure to reach out to you directly afterwards. And slides will be provided after the presentation, or they can be downloaded right now under the Handouts tab. And finally, for more info on our law firm, visit springlaw.ca, where we have a variety of great resources. These include our award-winning weekly blog posts, a link to subscribe to our monthly newsletter, information about our subscription program for employers, our Bill 47 ebook, which will bring you up to speed on all the Employment Standards Act changes and where it stands currently, and our ebook for recently fired employees who are looking for an alternative to in-person legal services. Okay, let's jump in. I'll run you through a roadmap of the presentation or the session today. We're going to talk about attendance management, obviously, as the title suggests. We'll run through the Ontario Human Rights Code section that applies to this discussion. We'll talk about what is a disability and the duty to accommodate that can arise when an employee has a disability. We'll talk about the standard of undue hardship and how to know if and when that high threshold has been met. We'll talk about accommodating absenteeism, absent employees, frustration of contract, and the risks of terminating an employee with a long but justifiable absence. And then we'll run through some takeaways for both employers and employees. And at any given time, we have a number of clients who are dealing with matters or challenges relating to employees with disabilities or absenteeism issues. So we'll weave in some practical suggestions based on the real life challenges we hear from you folks, both as employers and employees who are dealing with some form of disability and wanting to understand their rights and obligations. I'm going to hand it over to Hilary now.
Great, thank you, Marnie. So attendance management, as Marnie said, and these issues with employees with disabilities is something that we're seeing more and more, almost, I'd say, in every employer client. This will come up at some point or another. It could be due to, an aging workforce, and also the cohort of workers we have who are balancing demands from older parents as well as younger kids. So we'll talk about association with someone with a disability and how that ties in. And our workplaces are increasingly accessible and increasingly diverse. And these issues just come up all the time. So one thing we always recommend to employers is to have really clear attendance management policies and instructions regarding managing absences. So this will sort of help to head off problems so that everybody knows their obligations and how to handle a situation where an employee might need time off. So for example, your policy should include things like what counts as a sick day? Does a scheduled doctor's appointment, can you use a sick day for that? Who should employees go to when they need to take a leave of absence? Is medical documentation going to be required from an employee if they're just taking a day off sick? Stuff like that. So there's lots of issues to unpack there. The Human Rights Code is where these obligations on employers to accommodate arise from. So this is just a section of the Human Rights Code that requires accommodation in employment and freedom from discrimination. So you'll see there we have disability. And as I mentioned, discrimination can also arise because of association. So that's where maybe your employee themselves, they don't have a disability, but they're caring for a disabled partner, a disabled family member, and they are protected by the Human Rights Code as well, even though they themselves are not the disabled one. And so that's something to think about too. Those employees will need to be accommodated as well.
Okay, disability is defined in section 10 of the code, and I won't run through these bullets in detail, but suffice it to say it's a very broad definition that covers all kinds of physical and mental disabilities, impairments. And what I want to say about disability is obviously it can be a lot easier to understand a person's accommodations if you understand something about their disability, but due to privacy protections and confidentiality of the employee, sometimes employers don't have all that much information. So they're entitled to request what they need to understand the obligations, the accommodation obligations. But other times employees will volunteer information about their illness or their disability. And sometimes that can be helpful in the accommodation process. So I would say take their lead when they offer that information, and if it leads to a constructive, hopefully it'll lead to a constructive dialogue about the accommodations that they're requesting and that are possible from the employer's standpoint, because there's a request and then an assessment of whether the accommodations are possible. It's not an employee asks and employer must find a way. It's always a dialogue about what's possible and what's reasonable. So take an employee's lead if they offer that information, and I would say, document the fact that they've offered the information about their situation and, when they told you this and on what date, just to protect against, a potential allegation later that the employee pried and asked for confidential medical information. And it's a good idea to start an employee accommodation file and keep notes of these kinds of conversations, and understand, to help understand what the next steps are. And obviously be very discreet with the information that the employee offers. And you may even say to them, do you mind if we speak with your direct manager? You've now disclosed to me a little bit more about what's going on with you. Do you mind if we have a confidential discussion to better understand how we can accommodate you? And they may or may not agree. So it's really a two-way street, a dialogue with them about what their needs are, but again, they've offered the information and they've started the dialogue, which can be helpful in lots of cases. So moving on to the duty to accommodate, when is this triggered? So an employee may make a formal request by email or in some other written format, or they may verbally say, look, I have a situation, I have an illness or a disability, and this is what I think I need. And in that case, it's easier to identify what the next step should be for the employer. But sometimes an employee might be going through something and they don't know to ask, they don't want to ask, and there is an obligation on an employer to make inquiries if they notice that an employee is uncharacteristically, for example, absent or showing up late regularly, or something might be going on with them. So identify who in the workplace has a rapport with that person, whether it's at HR or someone wearing a people ops hat, or if you don't have somebody in that designated function, find someone ideally at the management level who can confidentially make inquiries to understand what accommodation requirements might arise. And I'm going to hand it back over to Hilary to talk about undue hardship.
Yes, thanks. So the duty to accommodate ties into this concept of undue hardship, and these all come from the Ontario Human Rights Code. The standard of undue hardship is the standard to which the employer has to accommodate the employee. So up to the point of undue hardship. So what is undue hardship? is sort of always what we're looking at, like how far do we need to accommodate these employees' requests, and what point is going to be undue hardship. So the employer, you may need to change their rules or policies to allow for the employee to access opportunities equally and to participate fully in the workplace, even if they do require accommodations. So people can be really creative about accommodations, and the law requires quite a high standard. So how do we know what undue hardship is? The Human Rights Code lists 3 ways of assessing whether an accommodation would cause undue hardship. So these are the 3: cost, outside sources of funding, and health and safety requirements. Something costing extra does not mean it's going to be undue hardship. And in a small business context, often there's going to be outside sources of funding from the government that will help with that cost. So let's say an employee needs like a totally different workspace, all ergonomically designed and whatnot. That's going to cost some money, but there may be outside sources of funding. And the cost has to be, for cost to equate to undue hardship, it's got to be like really, really costly and actually injuring the business likely. So undue hardship is definitely a high standard. I don't know if you have anything to add to that, Marnie.
No, I think that was a very thorough guidance on the issue.
Okay, thank you.
All right.
I'll turn it back over to you. Oh no, this is mine, sorry. So absenteeism is kind of what we're talking about here. And when you have an employee who requires time off, that's sort of their accommodation requirement. And that's a very common one, because if people get ill or, they often just can't actually work. So their accommodation is going to be time off. So how much time off is too much time off? And that's where we're going to be looking at, have we reached the standard of undue hardship? So often you're going to have to replace that employee who's having time off with someone temporary. But it doesn't mean just because they can't work that you can give their job away, right? Because they are entitled to that accommodation. We often are asked, you have to keep paying the absent employee. Generally, if they're not working, you don't have to pay them. But you always need to continue their benefits generally. So they still get those sort of baseline entitlements of being an employee. It's just that if they're not actually able to do the work, probably someone else is doing their work and you're paying someone else. So, accommodating an absenteeism is not going to necessarily mean you're paying 2 salaries. So we come across situations where there are too many absences. A termination in these situations could be justified if the employee is just skipping work and they have no reason. So, but this would sort of trigger the duty to inquire on the part of the employer. So the employer is going to notice this person isn't coming to work. Is there a justification for that? Do they require accommodation? If they refuse to participate in the accommodation process, assuming those things are really, really well documented, then those may be situations where where a termination may be justified. There are a lot of hoops to jump through prior to that, though, so don't act on your own, employers. And then, otherwise, we're going to be looking at accommodating absences. So if that's the accommodation needed and we're not reaching the point of undue hardship, those accommodations are going to be justified and the employee is generally going to be entitled to some time off to get well.
Okay, and I do have something to add to that, Hilary, this time. Just in terms of to the point of getting medical documentation. It all comes back to the doctor's recommendations, or whatever the medical professional's recommendations are. We're not doctors. The employee's not a doctor typically. So we really have to go and read the last doctor's note, and if there are a few of them, and really make sense of what the doctor's recommending. And that's where we're basing, as lawyers, advice on, and that's where employers should be looking at. And if there's not enough information, I'm going to talk about some strategies to fill those gaps. It really does all come back to the medical documents. That's how you figure out how much time is needed. And I recognize it's not always clear cut, but that's where the starting point is. So I want to talk about the employee's duty to participate in this accommodation process. So the employee needs to help the employer accommodate their specific needs by obtaining and providing documentation. So they have to help the employer, and I always refer to it as a two-way street. It's a conversation about what the employee thinks they need to move forward in a positive, productive manner in the workplace, and the employee takes that information and in a good faith manner and decides, yeah, we can do this, or no, we can't, and document why that can't be done and why that might be moving closer to an undue hardship threshold. So, and again, this documenting is very important. Every bit of the employer analysis should be documented to be able to support later. Look, we did a really good faith analysis to try to be creative about this person's accommodation needs. And so in terms of the employee's participation, they need to obtain updated medical documentation, and employers should ask them to sign an authorization that allows the employer to freely provide information about their status. And the employer can really help the doctor understand what the employer is looking for, and really it's what's this person's restrictions, and the doctor understands the disability and what are their restrictions. And it's very helpful to provide a job description to the doctor and a covering note explaining what they do, and just helping the doctor understand how important it is to give more color to the restrictions, because we all know how unhelpful a one sentence or two sentence note from a doctor is that just comes in on a regular basis. So going that extra step to prepare materials for a doctor so that you get more fulsome medical opinions can be very helpful.
And I would just add in offering to pay, because often doctors are going to charge a fee for that, and the employer should usually be paying for that.
Yes, good point. And in the big picture, you want to limit requests to what's reasonably necessary to respond to the accommodation request. So the employer, again, back to that confidential medical information, we always include, and the doctors generally know this, but we include reference to the fact that we're not looking for confidential information, as in don't provide that to us. That's if the employee wants to have a more fulsome dialogue about it, that's their choice. But we don't want that from the doctor. We just want information about the restrictions, and the employer has to do what they can to maintain confidentiality throughout the process. And the failure to actively participate in the accommodation process by an employee can relieve the employer of their responsibility to accommodate the employee. So it's back to that two-way street. There are important obligations on both the employer and the employee, and that's why it's really important for the employer to carefully plan the accommodation process, document it, and if the employee is not cooperating, then the next conversation is this isn't working out, and that's where legal advice is highly recommended to figure out, is there a way to exit this employee because they're not cooperating, or we've reached the threshold of undue hardship. We try hard to help our clients with whatever they can handle on their own in terms of a DIY process and providing materials so that they can find solutions and not have to call a lawyer each time they have an issue. But this would be an example of, I would say, a landmine, and it's very tricky to do this assessment and figure out how an employee should be treated, and at what point it's time to figure out an exit strategy because the obligations are not being fulfilled. Contacting an employee on leave. So if an employee is on leave, they have an obligation to provide regular updates and updated medical information. And it's a contextual analysis throughout this entire process with every employee. It depends on the circumstances in terms of how often they should be in touch and what level of detail you need from the doctor. So part of the accommodation plan should actually involve talking to the employee and saying, okay, we're going to require bi-weekly updates or monthly updates, or how about every 3 months you check in. Again, it'll depend on why the employee is off or what the particular accommodation request is. So it goes a long way for the employee, for them to understand what the request is, what the time frame is, and then they have that obligation to stay in touch. So and the employer has to ensure that the frequency of the contact is reasonable. So again, that can be a discussion with the employee. Ultimately, it's the employer's decision, and they will set the parameters and say, look, this is when we need the updates. But it is always helpful, and I find, you know, we achieve better outcomes as employers when the employee is involved in the plan and the process.
And I think often employers think, oh, we can't talk to them, they're on a leave. But that's, you know, not necessarily the case, because keeping that two-way street open and keeping in touch, keeping up to date is really, really important. Well, you don't want to be harassing the employee, contacting them every day, but definitely reasonable contact, you know, we think is a good idea.
For sure. And I think a common sense human approach always goes a long way. I mean, if you have somebody who's off with a genuine disability, emphasizing that, you know, there's concern for their health and their health is the biggest priority, and reassure them of that, but then say, look, this is now what we need from you. And you know, we need you to get this information to us, and, you know, can you get it by this date? And if not, how about by this date? And work with the employee. If you have someone where the accommodation requests are not genuine and you feel you've got an employee who's taking advantage of the situation, then you know, you become more robust in the process, and you set more firm requirements, and then you start down a path of you're not fulfilling your obligations, and that's where termination exit discussions can start to happen, because they're not fulfilling their obligations. Frustration of contract is the next topic, and ties in nicely with my last comments. Frustration of contract can occur where unforeseen circumstances that make it virtually impossible to execute the terms of the contract occur. And this is where you have a medical opinion that confirms, I would say unequivocally, that there's no reasonable likelihood that an employee will return to work within a reasonable time frame. And in other words, that their illness or disability is permanent. And at that point, the employer should get legal advice and consider a termination for frustration of contract, which is different for a regular termination without cause, where notice or severance package needs to be provided. Often folks think that a 24-month mark is the magic number for frustration of contract consideration, but if that unequivocal medical opinion happens at a 2-month mark or 6-month mark, where a doctor says this person is permanently disabled, then that conversation can happen sooner. So the case law, the time frame for when frustration of contract has been deemed to be permissible in the courts, the number of months, it actually does fluctuate. So 24-month mark doesn't have as much magic as some people think. Do you have anything to add on frustration of contract?
Yeah, I would just add that frustration is usually just going to arise where the employee is being accommodated by being totally off work. So it's a situation where they are disabled to the point that they are unable to do their job at all. And a different situation may arise if an employee has a permanent disability, but that's a disability that can be accommodated, right? So you know, maybe they need to work shorter hours, or they need, you know, different arrangements. That's likely a situation that's not going to meet the frustration bar, even if those changes end up being permanent. So moving on to the risks of terminating an employee with a long, though justifiable, absence. So this is just sort of what's the worst case scenario. So we're saying justifiable absence because that's going to be an absence, not that the employee is just skipping work, but that they had a real justified reason. For example, they, you know, have a disability and they can't come to work. What if you did terminate that employee as an employer, what's going to happen? So the employee is going to be looking for damages for wrongful dismissal. And then there's also going to be the risk of human rights damages and potentially also bad faith damages. So these are all claims that an employee could bring against the employer if they were terminated without the employer having met that undue hardship threshold. So there's going to be notice damages for the dismissal itself. There could be bad faith damages, as I said, for the manner of dismissal if the employer was unduly insensitive in terminating this employee, because of their disability, and then human rights damages because a protected ground like disability cannot be a consideration in why the person was terminated unless that undue hardship threshold has been met. So those can really add up, and in terms of bringing an application to the Human Rights Tribunal of Ontario for employees, this is pretty easy and there are no cost consequences. So it's not like in court where there's some risk to the employee that if they should be unsuccessful, they end up having to pay the employer's costs. That's not going to happen in a human rights tribunal situation. So it's definitely something we try to avoid, and we do try to document everything, as Marnie said, with an accommodation file. If we do need to terminate, we really want to make sure we have a good case set up for the employer did everything they could and undue hardship has been met.
Mm-hmm. And that can include details such as, our clients' needs weren't being met, revenues are taking a hit, we're too small to find a replacement employee for this extended period of time. There's just nobody who can fulfill this job anymore. And this is a high threshold, and there is an expectation that employees find alternative measures for a certain period, but it's important to document the pain points that the employers are feeling throughout the process, and then assessing, okay, are we getting close to this undue hardship threshold? And again, it's a tough bar, it's a high bar to meet, but recording all the challenges along the way might, number one, make you think of other ways that this or accommodation can be met, but also, and look, this really isn't, look how many things we've tried, and we just can't get to a point where this is a workable solution. Yeah. So really documenting those creative solutions and speaking regularly with the employee about what they think would work for them, what they need. And it's an ask. It's not, you're not making any promises. It's just help us understand what might be workable. Because sometimes that solution is not the obvious one. And we've had matters come to where there's been a good outcome just by really hammering out a plan and being creative with the employee.
Yeah, totally. And I would also just add that often we see employers saying, well, this person has performance issues and that's why I want to terminate them. It doesn't have anything to do with their disability or their accommodation needs. And those situations, we really need to look closely into that and really parse out, are these performance issues related to a disability or a protected ground? Because if they aren't, maybe that could support the case for termination, but those, we really need to look into them and not just make that assumption. So takeaways for the employer: clear lines of communication with the employees during leaves are really important. So just because an employee is on a leave, it's not like we just forget about them and leave them alone. Getting that up-to-date medical information, getting new information about the prognosis, that is essential. And we always recommend, of course, getting legal advice before making any decision that would end the employee's job, right? So either due to frustration or deciding to terminate the employee, because we really want to make sure all of our ducks are in a row before anything, any drastic step like that is taken. So up-to-date medical information, super, super important. And just everything in writing, as we like to say.
You're sounding like a lawyer, Hilary. You don't usually sound like such a lawyer.
Oh, really? That's very flattering.
You're welcome. Takeaways for the employee. So as we would all know by now, after hearing Hilary and I go on about this, employees are entitled to request and receive workplace accommodations. and employers should accept those requests in good faith and take a hard look at what the ask is, what the accommodation request is, and do the hard work to be creative about solutions and show your work, so document it. And if you get to a solution, you get to a solution. If it's just not workable, then hopefully everything's documented and there's been lots of creative solutions tried. And then the next conversation is, are we getting close to undue hardship? And that assessment happens after a process, and it typically takes some time, a few months, to get to that point. And remembering that accommodation will look different for different people, even if two people have the very same condition. There's lots of factors in an employee's life that might mean they have different accommodation needs. So again, it's about that dialogue with the employee and making them feel heard in the process, that they have they're participating in the process. And regardless of the outcome, that typically does help, and the employee feel like the employer tried to accommodate them in the process and was respectful of their needs. So that brings us to the end of our session today. We hope you'll join us for our next webinar. It's on November 20th, and it's on tech in the workplace, the remote worker. And feel free to follow up directly with any of our lawyers if any questions arise out of today's program or any other types of workplace issues you may have. In addition to all the workplace law resources I mentioned at the beginning, which appear on our website, we encourage you to follow us on Facebook, Twitter, LinkedIn, and Instagram, and sign up for our monthly newsletter to stay up to date on all of these interesting workplace issues. Thanks very much for joining us today, and have a great day.
Thank you.